Hello viewers, in this lesson we will learn about the features and administration of the Depositories Act 1996. Viewers, now we will learn about the meaning of depositories, basic structure and important definitions under the Depositories Act. Meaning of depositories. During the 90s, the depository system was introduced in the Indian capital market. The depositories are intermediaries and play a very pivotal role in the securities market. Prior to this enactment, the stock exchanges in India adopted the system of paper securities to the issuer for registration, the transfer of the securities being evidenced by an endorsement on the security certificate. Deterioration, mutilation, theft, forgery and other irregularities relating to the certificates entitle the issuer to refuse the transfer of a security. Issuing a duplicate certificate was a very laborious process and it resulted in high costs and also delays in settlement, which resulted into restricted liquidity and made the investor grievance redressal very time consuming and costly. To overcome these problems, the Depositories Act 1996 was passed. A depository is a company where the securities of an investor are held in the electronic form at the request of the investor through the medium of a depository participant. The depository functions like a central bank, and to make use of the services of the depository, the investor has to open an account with the depository through a depository participant. A depository, to act as a depository, must obtain a certificate of commencement of business from SEBI. In India, two depositories are functioning, namely the National Securities Depository Limited (NSDL) and the Central Depository Services India Limited (CDSL). The depositories provide various services in accordance with the provisions of the Depositories Act to the investors and other participants, such as clearing members, stock exchanges, investment institutions, banks and issuers of securities. The depositories also provide basic facilities like account opening, dematerialization, rematerialization, settlement of trades and advanced facilities like pledging, distribution of non-cash corporate actions, distribution of securities to allottees in public issues and like ones. Basically, issuing paper certificates in huge number is avoided by the depositories. The securities are held by a depository in demat form, that is, the securities are dematerialized and they are kept in a fungible form. That means the ownership and transfer of securities takes place by means of electronic book entries, and by this the capital market rids of the dangers involved in handling of paper securities. The depository system results in several benefits like the elimination of dangers of paper securities, immediate transfer and registration of securities, elimination of bad deliveries, faster disbursement of shares arising out of rights and bonus issues, easy transfer and transmission of shares, brokerage benefits and saving of several procedural wrangles. The investor has to open an account with the depository through a participant like opening an account with any bank. The depository is regulated by the SEBI. Further, the Depositories Act 1996, the SEBI Depositories and Participants Regulations 1996, Bylaws and Business Rules of Depository, the Companies Act 2013, the Indian Stamp Act 1899, SEBI Act 1992, Securities Contracts Regulation Act 1956, Binomy Transaction Prohibition Act, Income Tax Act 1961, Bankers Books Evidence Act 1891, along with other rules and regulations framed thereon, govern the functioning of the depositories. The depositories are different from the providers of custodial services, as the depositories alone can legally transfer the beneficial ownership of securities. The investor has to open an account with the depository through a participant who is just like a broker or an agent of the investor in the stock exchanges. A depository participant, also called a DP, provides the link between the depository and the investor. The DP maintains securities, account balances, and intimates to the account holder the status of holding from time to time. Any financial institutions, banks, custodians, stockbrokers, and like organizations can become participants in a depository. In practice, the depository is like a bank and the DP is like a branch of that bank. The DP also must be registered with the SEBI under subsection 1A of section 12 of the SEBI Act 1992 and obtain a certificate of registration. Objectives and application of the Act. This Act was enacted by the Parliament with the objective to provide for regulation of depositories in securities and for matters connected therewith or incidental thereto. This Act extends to the whole of India. This Act has come into force on 20th September 1995, as prior to this legislation, 3 ordinances were issued. Basic structure of the Act. This Act is divided into 31 sections under 6 chapters. The schedule was repealed. Significant changes were brought into this Act by the Depositories Related Laws Amendment Act 1997, the Securities Laws Second Amendment Act 1999, the Securities Laws Amendment Act 2004. Some important definitions. 1. Beneficial owner. Clause A of subsection 1 to section 2 of the Act defines a beneficial owner as a person whose name is recorded as such with the depository. 2. Depository. Clause E of subsection 1 to section 2 of the Act defines a depository as a company formed and registered under the Companies Act 1956 and which has been granted a certificate of registration under subsection 1A of section 12 of the SEBI Act 1992. Subsection 32 of section 2 of the Companies Act 2013 defines a depository as it is defined in clause E of subsection 1 of section 2 of the Depositories Act 1996. Presently in India, only 2 depositories are functioning, namely NSDL and the CDSL, which are registered under the Companies Act 1956. 3. Issuer. Clause F2, subsection 1 of section 2 of the Act defines an issuer as any person making an issue of securities. 4. Participant. Under clause G, to subsection 1 of section 2 of the Act, participant means a person registered as such under subsection 1A of section 12 of the SEBI Act 1992. Under subsection 2 to section 2 of the Act, words and expressions used and not defined under this Act but defined in the Companies Act 1956 or the Securities and Contracts Regulation Act 1956 or the SEBI Act 1992 shall have the meanings respectively assigned to them in those acts. Viewers, now we will learn about the law on the rights and obligations of depositories, participants and others and the penal provisions. 1. Certificate of commencement of business. Section 3 of the Act requires every depository to obtain a certificate of commencement of business from SEBI to act as a depository. The SEBI must ensure that the depository has adequate systems and safeguards to prevent manipulation of records and transactions. In fact, the depositories and the participant must be registered with SEBI. 2. Rights and obligations of depositories and others. Sections 4 to 17 of the Act contain the relevant provisions in this regard. The important issues are: A. Agreement between the depository and the participant. Under section 4, it is mandatory that a depository must enter into an agreement with one or more participants as its agent. The agreement should be in such a form as may be specified under the bylaws of the depository. B. Services of depository. The services of a depository are available to any person but only through a participant. Under section 5 of the Act, any person can avail the services of a depository through a participant, and he must enter into an agreement with the depository in such a form as may be prescribed under the bylaws, but through a participant only. A participant is an agent of the depository and he must be registered with SEBI. C. Surrender of certificate of security. The holder of security is called the beneficial owner for the depository. The depository is called as a registered owner for the issuer of securities. Under section 6 of the Act, any person who enters into an agreement with a depository must surrender the certificate of security he is holding, for which he seeks to avail the services of a depository, to the issuer in the manner specified under the regulations. The issuer, on receipt of the said certificate of security, must cancel it and substitute in its records the name of the depository as a registered owner in respect of that security and inform the depository accordingly. The depository, on receipt of this information from the issuer, must enter in its records the name of the holder of the certificate of security as the beneficial owner. D. Registration of transfer of securities. Section 7 of the Act requires the depository to register the transfer of security in the name of the transferee on receipt of such intimation from a participant, and if a beneficial owner or a transferee of any security seeks to have custody of such security, the depository must inform the issuer accordingly. E. Options of the holders of securities. Section 8 of the Act enables the holders of securities to opt to receive security certificate or hold the securities with the depository, and if he opts for demat form, the depository must enter the details in its records in the name of the allottee as the beneficial owner of that security. F. Securities in fungible form. Under section 9 of the Act, all securities held by a depository shall be dematerialized and shall be in a fungible form, that means in electronic form. G. Rights of depositories and the beneficial owners. Under section 10 of the Act, a depository shall be deemed to be the registered owner for the purpose of effecting transfer of ownership of security on behalf of a beneficial owner, and it shall not have any voting rights or any other rights in respect of securities held by it. The beneficial owner shall be entitled to all the rights and benefits and be subjected to all the liabilities in respect of his securities held by a depository. H. Register for the beneficial owner. Section 11 requires every depository to maintain a register and index of beneficial owner in the manner prescribed under sections 150, 151 and 152 of the Companies Act 1956. Students are advised to refer to the equivalent provisions of the Companies Act 2013 wherever the 1956 Act is referred to. In this case, section 88 of the Companies Act 2013 is equivalent to sections 150 to 152 of the Companies Act 1956. I. Pledge or hypothecation of securities held in a depository. Section 12 enables a beneficial owner to pledge or hypothecate a security owned by him with the previous approval of the depository, subject to such regulations and bylaws as may be made in this behalf. Every beneficial owner must intimate the depository about the pledge or hypothecation of the security, and the depository must enter the details in its records, which is the evidence of such a pledge or hypothecation. J. Furnishing of information. Under section 13, every depository and the issuer of securities must furnish to each other the information about the securities held in the name of the beneficial owner in such manner as may be specified under the bylaws. K. Remat of securities. As provided under section 14 of the Act, the beneficial owner can opt to go out of a depository in respect of a security, and in that event he should inform the depository about his option, and on receipt of such information the depository must make necessary entries in its records and inform the issuer about it. Then the issuer shall, within 30 days of the receipt of such information from the depository, issue certificate of securities to the beneficial owner or the transferee, as the case may be, in accordance with the regulations and on payment of the prescribed fees. This process is called remat, that is rematerialization. L. Application of the Bankers Books Evidence Act 1891. As per section 15 of the Act, the Bankers Books Evidence Act shall apply in respect of a depository as if it were a bank as defined in section 2 of that Act. M. Indemnification of loss. Under section 16 of the Act, if any loss is caused to the beneficial owner due to the negligence of the depository or the participant, the depository must indemnify such beneficial owner. If the depository indemnifies the loss caused by the participant, it can recover the same from such participant. N. Rights and obligations. Under section 17 of the Act, the rights and obligations of the depositories, participants and issuers shall be specified by the regulations. Penal provisions. Sections 18 to 21 of the Act contain the penal provisions. Under Section 18 of the Act, the SEBI, in the interest of the public or in the interest of the investors, can call for any inquiry and information from any depository or issuer or the participant or the beneficial owner. Under Section 19, the SEBI is empowered to issue any directions. Under Section 19A of the Act, if any person does not furnish the required information, books, documents, returns, or fails to maintain the books of accounts or records, or under Section 19B, he fails to enter into an agreement, or under Section 19C, he fails to redress investors' grievances, or under Section 19D, there is delay in dematerialization or rematerialization, or fails to reconcile records under Section 19E, or fails to comply with the directions of SEBI under Section 19F. The penalty is 1 lakh rupees for each day during which such failure continues, or 1 crore rupees, whichever is less. Under Section 19G, where a person commits any default for which no separate penalty is provided, under the Act, the penalty may extend to 1 crore rupees. Section 19H empowers the SEBI to appoint any officer not below the rank of a division chief of SEBI to be the adjudicating officer to impose penalties. He should not take any decision unless he gives an opportunity to the parties to be heard, and also taking into account the factors stated under Section 19I. Under Section 19J, the sums realized as penalties must be credited to the Consolidated Fund of India. Under Section 20, if any person contravenes or attempts to contravene or abets the contravention of any provisions of the Act or any rules or regulations or bylaws, he shall be punishable with imprisonment for a term which may extend to 10 years or with fine which may extend to 25 crore rupees or with both. Further, if the penalties imposed as stated afore are not paid, or the directions issued by the adjudicating officer are not complied with, the erring person is liable for punishment with imprisonment for a term which shall not be less than 1 month but extendable to 10 years, or fine which may extend to 25 crore rupees or with both. Section 21 pertains to the offences committed by companies and the persons responsible for punishment thereon. Viewers, now we will learn about the appellate provisions and other miscellaneous issues. Sections 22 to 31 deal with the miscellaneous provisions. Under Section 22, only the central government or the state government or the SEBI must make a complaint of any offence to a court of sessions. Under Section 22A, the SAT or the court can compound the offences. Under Section 22B, the central government can grant the immunity of the penalties. Under Section 23, before the commencement of the Securities Laws Second Amendment Act 1999, if any order is passed by the SEBI, it was appealable to the central government. After the inception of the Securities Appellate Tribunal, under Section 23A, any order of SEBI or its adjudicating officer is challengeable in the Securities Appellate Tribunal. Sections 23A to 23F contain the provisions on SAT. Under clause KA to subsection 1 of section 2 of the Act, SAT means the SAT established under the provisions of SEBI Act, and same provisions apply here also. The provisions are common to the issues under the SEBI Act, SECRA and the Depositories Act. The students are advised to thoroughly study these provisions. Section 24 empowers the central government to make rules. Section 25 empowers the SEBI to make regulations. Section 26 empowers the depositories to make bylaws. Under Section 27, the rules and regulations must be laid before the Parliament. The students are advised to thoroughly study all the provisions discussed in this lesson and also other miscellaneous provisions from the BEAR Act. Viewers, I hope you have enjoyed the lesson. We will meet again in other lessons. Thank you.